And we are live. Good afternoon and welcome to the April 30th edition of Litigating Despite COVID-19, a weekly webcast from the litigation section of the California Lawyers Association. I'm Mike Kelleher, a litigation graphics and litigation technology consultant at Cogent Legal, and I'll be running the technology behind today's webcast. Now I'd like to turn it over to Adrienne Ciccone, who will tell you what's ahead in today's webcast.
Good afternoon, everyone. Thank you so much for joining us this week. Again, my name is Adrienne Ciccone, and we have the pleasure of hearing from Marc Alexander, who is a mediator in Southern California's interview of Dean Chemerinsky, who works at the University of California, Berkeley School of Law, where Dean Chemerinsky gives us the constitutional authority for shelter in place and quarantine measures, in addition to some history behind that and answers to some very relevant questions. That presentation will last roughly 25 minutes. Following that, we will hear from Anna Sambold, who is a mediator in San Diego County, who will give us the updates which were just issued this week from the San Diego County Superior Court regarding their emergency orders. Finally, I will give you an update which was just issued yesterday from Chief Justice Kantil Sakauye regarding 90-day extension of criminal trials. Once again, we will hear from Dean Erwin Chemerinsky and Marc Alexander with the constitutional basis for shelter in place and emergency measures, Anna Sambold on an update from San Diego County Superior Court, and last, I will provide updates that were just released yesterday. And with that, I hope you enjoy the presentation.
Welcome to the video cast of the litigation section of the California Lawyers Association. My name is Marc Alexander, and I'm a member of the section Sheltering in Place. I'm very excited that our guest speaker with the California Lawyers Association is Dean Erwin Chemerinsky of the Berkeley School of Law. Our topic is the emergency powers of state and national government during a public health crisis. Dean Chemerinsky is a founder of the University of California at Irvine School of Law, a Supreme Court advocate, the author of many books, articles, and opinion pieces, a preeminent constitutional scholar, and a generous contributor of his time as a public intellectual and member of our profession. I think you will be amazed by his legal analysis and his astonishing memory of Supreme Court cases.
Welcome, Erwin.
It's a pleasure to be with you.
Thank you. And let's jump right into it. Can you sketch for us the origins of quarantine power of state and federal government?
The power to quarantine long precedes American government. In the United States, soon after the Revolutionary War, there was an outbreak of yellow fever in Philadelphia, and there was a quarantine. In 1799, Congress passed a statute that made it clear that the power to quarantine is at the state level, not at the federal level. State and local governments have broad authority to quarantine or order things like shelter in place or closure of business to stop the spread of communicable disease.
Thank you. And how has the quarantine power evolved since colonial times and during World War II and afterwards?
There's no doubt that the government retains the power to quarantine. The Supreme Court explicitly said in the 1920s that the government has the power to quarantine for the sake of public health. Most recently, in 2016, a federal district court in New Jersey ruled that a nurse who had been treating Ebola patients in Africa could be quarantined about coming back to the United States. What we're seeing now like shelter-in-place orders, are just somewhat milder forms of quarantine. I could leave my house this morning to go grocery shopping, so it wasn't strictly being quarantined, but other than for things like that or walks, we're supposed to remain where we live.
Your colleague at the University of California, Irvine, Professor Katie Porter, who is now a representative in the House for Orange County, recently grilled the director of the CDC, Dr. Robert Redfield, and she said to him, "Doctor, you have the existing authority to promise the American people that if they are tested for COVID-19, they will not need to pay for it." Does he have that authority, and where does it come from?
I assume, based on what Representative Porter said, there's a statute that gives to the federal government the authority to pay for such tests. And you might remember that in response to Representative Porter's questions, he said the federal government would do this.
And do you see a conflict between quarantine powers to shutter businesses and end meetings and order people to stay at home? Do you see a conflict between those exercises of emergency power and constitutional rights?
Obviously, quarantine orders, shelter-in-place orders, closure of business orders are an infringement of freedom, but they're constitutional under the current circumstances. In 1905, in Jacobson versus Massachusetts, the Supreme Court recognized the broad power of government to stop the spread of communicable disease. That case involved requiring people to be immunized with regard to smallpox, and a person said, "This is infringing my liberty. I should be responsible for my health." And the Supreme Court ruled against him and upheld the state law, making clear that our freedom can be limited so as to protect the health of others and to keep our medical care system from being overwhelmed.
Is this generally an application of one of John Stuart Mill's principles on liberty, that actions that are prejudicial to the interests of others, the individual is held accountable for and be subject to social or legal restrictions as society deems necessary?
Yes, I mean, what John Stuart Mill said was that a person's liberty is limited in that the person can't use his or her liberty to harm somebody else. There's the famous adage, "My right to swing my fist stops at another person's nose." A person can certainly endanger his or her own health, but the problem with the communicable disease is it can then be spread to others. And the problem with this particular communicable disease is if too many people become ill, there's a real threat. It can overwhelm the healthcare system.
What legal tests should be applied determine whether what broadly calling quarantine rights, but really are emergency powers of the government? What legal tests should be applied to determine whether those extraordinary powers are being properly exercised?
In Jacobson versus Massachusetts, the Supreme Court said there has to be, quote, "a real and substantial relationship to public health." And that's what a lot of lower courts have been using in just the last couple of months. And so this doesn't mean the government can do anything it wants in the name of stopping the spread of a communicable disease. Its actions need to have a real and substantial relationship to protecting public health.
Now, some conservatives like men have argued that if these powers impinge on religious freedoms, a strict scrutiny legal test needs to apply. What is your take on that analysis?
It's wrong on many levels. First, if it is a general law, religion gets no exception from it. So imagine the regulation says there can't be gatherings of more than 10 people. Religion isn't entitled to an exception from that. In 1990, in Employment Division versus Smith, the Supreme Court said, in an opinion by Justice Scalia, that religion is not entitled to an exception from a general law. Second, the test with regard to all liberties in stopping the spread of communities, I think, is a real and substantial relationship test, not a strict scrutiny test. Applied to religious gatherings, if it's about a large number of people assembling in a church or a synagogue or a mosque, stopping the spread of communicable disease will allow prohibiting such religious gatherings. Now, imagine that there's a desire to have people in their cars come together in a parking lot for a drive-in type ceremony where nobody gets out of their cars. I don't think there's a real and substantial relationship with regard to public health to preventing that. But in-person assemblies for religion, no doubt the government can stop those, like you can stop in large assemblies for any other purpose right now.
So is a least restrictive means test applicable to these issues where religion is involved?
Well, again, if it is a general law, religion is not entitled to any exception to it. You never get to least restrictive alternative. The Supreme Court, in Justice Scalia's opinion, said the free exercise clause cannot be used to challenge such laws of general applicability. But I think even as to other rights, I don't think it's going to be a strict scrutiny test or least restrictive alternative analysis used. I think the question is, does the government action to stop the spread of communicable disease have a real and substantial relationship to protecting public health?
How strong, how firm do you think Justice Scalia's opinion will be as precedent going forward?
For right now, it's the law. Next fall, the Supreme Court has a case before it, Fulton versus City of Philadelphia, that one of the issues presented is whether the court should revisit Employment Division versus Smith.
And I note that on April 13, the LA Times reported that 3 churches have sued Governor Newsom, arguing that social distancing orders violate the First Amendment right to freedom of religion and assembly. And a similar type of challenge was mounted in federal district court in Kansas in First Baptist Church versus Governor Laura Kelly. What's your analysis?
I think those challenges will lose for just the reason I said. The government can stop people from assembling in order to prevent the spread of communicable disease. That includes stopping people from assembling for religious worship. The reality is, if people get together, including for religious worship, they can spread the communicable disease, and that really threatens our healthcare system.
Now, some states have used the circumstances surrounding COVID-19 pandemic to pass orders prohibiting abortions. And the arguments have been, number one, that abortions are elective surgery or, quote, minor surgery, close quote, and also that that surgery makes use of personal protective equipment, which is needed to fight the COVID-19 crisis. What would your analysis be of those cases?
Every federal district court to rule has struck down those restrictions. The Fifth Circuit initially in a 2-1 decision upheld Texas law. Then it modified it to say that it couldn't be applied with regard to medically induced abortions. Medically induced abortions, abortions caused by drugs like RU-486, don't involve surgical procedures at all. So there's no reason to ban them at this time. To me, banning medically induced abortions just shows that what those governments were trying to do wasn't about public health. It was using this crisis to try to stop abortion. Also, abortion is different than many elective procedures because how much time matters. At some point, the passage of time will mean the woman can't have an abortion at all. Also, the further in pregnancy it goes, the more dangerous the abortion becomes. Keep in mind, abortion is one medical procedure where there's a constitutional right of women to have it if they choose to do so.
Now, is the president legally limited in his ability to order companies to produce vital medical equipment during the crisis, such as masks or ventilators or test kits? And specifically, does the case of Youngstown Sheet and Tube Company, in which President Truman seized the steel industry, does that have any application to the reach of the president's power to order such things from companies?
The Defense Production Act gives the president the authority to order companies to produce things that are needed for the national defense. That makes it different than the Youngstown case, where there was no statute that authorized the president to seize the steel mills. Indeed, in that instance, Congress had considered passing such a statute and it refused to do so.
So then if the president had the will to do so, he could be ordering companies to produce these medical products.
The Defense Production Act gives the president authority in that regard, and many believe the president has underused this authority given the shortages of things like ventilators and protective equipment.
Can states provide civil immunity to doctors and nurses and first-line responders dealing with the COVID-19 health crisis?
They can. There are other instances in which the federal government or state governments have provided immunity in particular instances. And so if they wanted to, they could pass such a law. I don't know that it's necessary, but it's possible.
Suppose a citizen in a state, let's say Georgia, for example, believed that stay orders were being prematurely lifted and that this posed a threat to the health of the citizens of the state. Would a citizen have any standing to challenge that in court, and would there be any legal basis for doing so?
As you presented, I think the answer would be no. The Supreme Court has said that generally the government has no duty to take actions to protect people from harm. There was a 1989 Supreme Court case, DeShaney versus Winnebago County Department of Social Services. It involved a young boy, Joshua DeShaney, who was 4 years old. He was severely beaten by his father and suffered irreversible brain damage. Joshua's guardian sued the Department of Social Services, saying its failure to respond to complaints of child abuse over a 2-year period cost Joshua's liberty without due process. And the Supreme Court made it clear that the government generally has no constitutional duty to protect people. Only if somebody is in government custody, or if the government literally creates the danger, is there any duty to protect. So I don't think Georgia can be held liable, even though I think what Georgia is doing is very irresponsible.
Are the facts different from the case that you just cited? Once the government has already taken steps to intervene and protect. In other words, if the government is not taking any steps to intervene and protect, it may have no duty to do so. But once it takes steps to intervene and protect, does that create a different situation?
No, I mean, the Supreme Court has said there's two situations the government has a duty under the Constitution to protect. One is if somebody's in government custody, for example, people are in jail because they can't protect themselves, or if the government can be thought to literally create the danger. And if there's a state-created danger, then the government has a duty to provide protection. Just because the government started, say, with shelter in place, doesn't mean there's a constitutional duty for the government to continue it.
Now, it has recently been reported that the Internal Revenue Service has taken the position that American citizens who are married to immigrants without a green card and without a social security number are blocked from receiving stimulus payments. And this may be an evolving situation, but what would your legal analysis of that situation?
I think it's a terrible policy, but I think it'd be hard to say that it's an unconstitutional one.
Well,
In a case called Matthews versus Diaz, the Supreme Court said that Congress has broad latitude with regard to giving or denying benefits to non-citizens. In fact, the court said, when it's a decision to deny benefits to non-citizens, only rational basis review is used. The government will prevail so long as its action is reasonable. So I think in this instance, I don't like the policy, but I think it'd be hard to find it unconstitutional.
so I have a question that's really two questions folded into one. The first part is that President Trump recently said that he had absolute authority to open up the economy in the states. And the second connected part is that Attorney General Barr recently said that if states did not open up, he might exercise some legal remedies. And you might want to take that as one question or as two questions.
The president and the attorney general have no legal authority to order businesses to open. The state governors have issued closure orders, period. Now, let me explain. States have the police power and can do anything not prohibited by the Constitution. This includes the power to quarantine or to shelter in place and closure of business. The federal government can act only if there's constitutional or statutory authority. There is no constitutional provision that remotely could be interpreted to give the president the authority to open businesses when the governor has closed them. Nor is there any federal statute that permits this. The Public Health Act says that the Surgeon General and Health and Human Services can act to stop the spread of communicable disease between the states or from coming into the United States. Ordering businesses to open isn't remotely about stopping the spread of communicable disease. And the Public Health Act has a provision that says this does not preempt any state actions or state laws. The Attorney General could certainly file friend of the court briefs if people sue for opening, but there is no statute that the Attorney General can use to override a state decision to close businesses or require people to shelter in place, period. And for President Trump, we excuse his ignorance of the law. I think that the Attorney General should be ashamed for saying he has this authority when it clearly doesn't exist.
Is this a 10th Amendment analysis?
Yes, the 10th Amendment is where it says that states can do anything that's not prohibited by the Constitution. The federal government, though, has to have constitutional authority. The 10th Amendment says all powers not granted to the United States nor prohibited to the states are reserved to the states and the people, respectively.
So I have one more question that relates to status of immigrants and immigration. President Trump has issued an executive order that further limits immigration. And I think that the explanation has been that this is to preserve jobs for Americans, and this is also because of concern about COVID-19. And in this area is the president's power plenary, or are there any limitations that you see on his ability to limit immigration in connection with the COVID-19 crisis?
Presidents have very broad power with regard to immigration. In Trump versus Hawaii in June 2018, the Supreme Court recognized this under the Constitution. Also, federal statutes give the president broad power with regard to immigration. But no power is unlimited. The president's decisions still have to be reasonable. UCLA law professor Jennifer Ciccone and I wrote an op-ed that was in the New York Times on Thursday, April 23rd, in which we argued that this exercise of power is unreasonable. And even under the broad deference given to the president, this shouldn't be allowed. There's no reason to believe that this is doing anything to advance public health. Already, the government is quarantining some who come from foreign countries for a 14-day period. That can protect public health. Nor is there any reason to believe that this would do anything to save jobs for Americans. There's got to be a better reason for a presidential policy than to please his political base and help his reelection campaign.
And I have one last question, Erwin, which is, when this COVID-19 crisis is over and we don't have to shelter in place, what's the first thing you're going to do?
Oh, wow. Will there be a baseball game to go to? I would love to go see an A's game or a Giants game, or fly down to LA and go to a Dodgers game with my kids. I hope there'll be a point that we can go to a restaurant again soon. I realize we don't eat out that often, but I took for granted the ability for us, on a Friday night to go out to dinner. But I look forward to being able to teach in person to my students. I realize how much I've been a law professor for 40 years. I've taken for granted the joy of being in class in person. I realize how much I've taken for granted just walking through the halls of the law school and running into people and getting to have those kinds of conversations. So all of those are things I look forward to.
Thank you. And this shall pass. Stay safe, stay healthy, and be well.
You too. Thank you.
Yes, thank you so much, Mike, for your expertise. Now I have the pleasure of introducing Anna Sambold, who is an amazing mediator in San Diego County, and she will provide us with the recent updates from the San Diego Superior Court regarding their emergency orders. Anna?
Thank you, Adrienne. Good afternoon, everyone. I hope all of you are well and managing this crisis. I'm a member of the San Diego County Bar Association and a member of the Executive Committee of the California Lawyers Association Litigation Section. And yesterday, April 29, the San Diego County Bar Association and 45 partnering local law-related organizations, including the California Lawyers Association, hosted an informative webinar presentation about the San Diego Superior Court. Well, the presenters were the presiding judge, the assistant presiding judge, and the court executive officer, Michael Rudy. They all discussed recent changes to court operations in light of the COVID-19 pandemic, and they all responded questions previously submitted for an informative Q&A. In general, the court is very concerned with the health and welfare of the court users, justice partners, and court staff, and is implementing a series of changes to follow social distancing rules as recommended by several public health guidelines and public health agencies. The San Diego Superior Court changes and updates are on the website at www.sdcourt.ca.gov. We'll provide these links on the bottom of the video if you want to have them. But as indicated on the website, all San Diego Superior Court locations will be closed to the public through May 22nd, 2020, except as to those matters listed on the website. But what civil court services are currently available? Well, between March 17, 2020 through May 22nd, 2020, The only civil court services available during this period are initial ex parte requests for gun violence emergency protected orders and civil harassment, elder abuse, gun violence workplace, violence and school violence TROs, requests to renew restraining orders that are expiring, emergency ex parte hearings regarding claims of exception, emergency lookout proceedings in landlord-tenant disputes, unlawful detainer cases, petitions for grants seeking emergency relief in landlord-tenant matters, unlawful detainers, claim of right to possession in unlawful detainer proceedings, ex parte hearings to stop utility shut-off from occurring, and emergency grants challenging COVID-19 quarantines and emergency measures. All these type of cases are listed on the San Diego Superior Court website. And as to all matters scheduled to be heard between March 17, 2020 and May 22nd, those matters will be continued to a new date. As additional information becomes available, it will be posted to the court's website. The presiding judge reported yesterday too that since the court closure on March 17, they have around 10,000 people in all the 4 courthouses for emergency proceedings. They have done 667 video hearings. They are all criminal essential hearings. They have done 447 bail reviews by telephone. And in civil, they have done 346 civil TROs. And in family, they have done 610 family TROs. They have started to do family ex partes too. And a highlight of the report too is that they have set up mailboxes for every case type: civil, criminal, probate, family, small claims court, and appeals. And they have received thousands of emails, and they have responded to pretty much all of them. So if you have a pending case, please first check the frequent asked questions provided on the website. And if you still have a case-specific question, please send an email to the relevant address provided on the website. Non-case-specific questions will not be answered, and the court will not accept documents submitted through these email boxes. And remember, you must include your name and case number. I encourage you all to read those new releases on the court's website and on Twitter. And as the court prepares to reopen, more information will be released. And these are challenging and unprecedented times. We will get to this, but it will take patience and time following social distancing rules to prevent a recurrence of COVID-19. In the meantime, I want to remind all lawyers and litigators out there that while the courts are closed, you can still bring your cases to mediation or arbitration and get a resolution and closure. Many mediators and arbitrators like me are offering services online and by phone, so they can assist you with your case. Thank you for joining us today, and we hope this was helpful. Stay safe and stay well.
Thank you so much, Anna. We appreciate the updates. Now, I will provide you with updates that were just issued yesterday from California Chief Justice Cantil Sacauye. So, yesterday, Chief Justice informed us that the emergency orders would be changing to extend criminal trials that were to have been conducted under Penal Code 1382 to 90 days. This 90-day extension also applies to other extensions, and the total amount of the extension for the criminal trial under the specific penal code is 90 days. In addition, Chief Justice wants courts to be able to conduct trials, if possible, remotely, so long as trials can be conducted so that we can be in compliance with the state and healthy public health and safety guidelines. And if you are a court and you require a later trial date please follow the specifications to request a trial date set forth in this order. You can find this order on the Judicial Council of California. It was published April 29th. You can also find the link to the order underneath our YouTube webcast. And with that, I want to thank you all for joining us. We appreciate your time. Thank you so much, Anna. Thank you so much, Mike. Thank you so much, Dean Chemerinsky, Marc Alexander. Should you have any additional topics you would like to discuss, please feel free to reach out to the litigation section of the California Lawyers Association, and we will be happy to provide you with the space to give us updates. Thank you again. Have a wonderful day.